We are, this is 121, and go down to Module 6, documenting the investigation. So let me bring that stuff up, which is here. Okay, so a preservation order is a court order you send to a person involved in a lawsuit saying you might be involved in a lawsuit and you must preserve the data. So you cannot delete the data because a lawsuit is coming. This is quite important, and so then you have to preserve the records and retain it for a period of 90 days, which can be extended, and so on. All right. Now, service providers would typically like to inform the suspect that we have a preservation order for something like your emails, and then you might ask them not to inform the subject, and there'll be an argument about that. The most extreme case here is a national security letter, which is enabled since the Patriot Act passed. And a national security letter is supposed to be used only in cases of terrorism, but you are not allowed to ever tell anybody that you handed over data to the government. You aren't even allowed to consult your lawyer. There's no way to protest in court or complain about it. So there is no way for any abuse of it to ever be detected or prevented. So it is pretty extreme, and a lot of civil liberties people are very unhappy with those national security letters. But currently they are still legal. All right, so when you go to a crime scene, you have to document everything there. There's going to be equipment in there like PCs and cell phones and micro SD cards and everything else. So you photograph or video everything there and intact, especially all the connections between devices. So if you take them apart and take them back to the lab, you can put them back the way they were, know where they got taken from, and you make an evidence list of every item uniquely identified by something like serial number and so on. So you know exactly what you took. Then you put it in a tamper-proof container and you take it back to the lab, and then you can testify in court that I seized it. I made sure that nobody tampered with it until I brought it to the lab. Then I locked it up in the evidence room or the evidence safe and made sure nobody tampered with it until the next person checked it out. And you have a chain of custody. So this chain of people can testify in court that I made sure nobody was tampering with the evidence, which is real important. So you seize this stuff. Like I say, very often, your defense will argue about what you did. The evidence doesn't really matter if they can catch you making mistakes in how you handled the evidence. This is what happened in the OJ trial. There was some glove that was all important, and they had a broken chain of custody. So that glove was not effective as evidence. Let me check for comments. All right. Anyway, there are a bunch of official government guides for this. I've been finding these useful as I'm doing more consulting. Some people I'm working for are rolling out AI and generative AI products really fast, and I was real pleased to find official government recommendations how to secure that. These things are very weighty. If you don't know what to do, a very good thing to do is find the official government recommendation and do that. Even if it turns out to be wrong, at least you can defend yourself and say, well, I did what was very reasonable to do. I did what was recommended by real authority. It's a very good place to start. So you investigate the crime scene, record everything, get a chain of custody form, so whatever you've taken, you record, I'm now responsible for it, and I'm making sure that nobody tampers with it. And that's what it looks like here. You got the item. All right. And then you complete a computer worksheet listing all the details about the system so you can tell that device uniquely from other devices. There won't be any argument that the computer you're examining is not really the one you seized at the scene and all that jazz. And then you put it in tamper-proof things like these bags or something with tape and sealing on them. And hard drives are the same. Record everything so you can uniquely identify it. And for servers, record make, model, serial number, information about the server, just so it's completely unique and you know what you've got, all the drives, because you might be removing them later to image it. So you want to make sure you recorded which computer they came out of. And there are tools to help you do this. Case notes, frag view. You've seen in autopsy, there's a very basic one. Every time you make a case in autopsy, it has a page where you write down the name of the examiner and the case number and stuff. But there are tools that help you fill out a much more detailed form to make sure you've got thorough records of what you did. And then you're going to have to write a report. Ultimately, this is your deliverable of forensic examination is the report explaining what you did. Another deliverable is your testimony in court, which is based on that report. Be sure you understand time zones. If your case crosses more than one time zone, it's important to know which time zone you're referring to, and then you make a report. Now, this is somewhere you have to have good communication skills. Part of the report is technically precise. It may be the output of a forensic tool like autopsy or ENCASE or FTK, which will be pages of listing file names and processes and perhaps even hexadecimal data or something. But you also have to have the cover page, which is the only thing most people are going to read, which is a non-technical summary of what did you find. I went to the scene, I seized this computer, I examined the computer, and I found this on it, that this had been done and this had been done, the important stuff that shows either guilt or innocence. That's you. The technical part, which is basically an appendix, should conclude all the technical information so the opposing forensic examiner can duplicate everything you did. But that's only going to be read by the opposing forensic examiner. The judge and the lawyers are only going to look at the front page, which is the non-technical summary. And the same thing's true of vulnerability reports. Like Microsoft vulnerability reports, they have an executive summary which states what is the problem, how much damage does it do, how do I fix it, which products are affected, no technical details. There's an appendix somewhere, the technical details, but management just cares about that information. They want to know whether I do anything about it, and if I do, then I hand it off to my technical team, read the technical part and deal with it. But most people just want to have a general idea of what it means. All right, let me check for comments. Nope, nothing new. All right. So your report has a cover page, then you have table of contents, which is often helpful, and then, like I say, the executive summary. This summarizes what you did and what you found in simple, non-technical terms. Then you have a biography of the investigator, listing all your relevant experience. By the way, when you have a resume to get a job, they say it has to be 1 page or maximum of 2, because nobody hiring has patience for anymore. But expert witnesses are completely different. I've seen expert witness resumes that are like 30 and 40 pages long. You really list every talk you ever gave at a conference, every article you ever published, every course you ever taught, just everything you did, to have an overwhelming mountain of experience, pile of experience that will impress people. That's what it's for. Then you have, you may discuss the purpose of the investigation, you may not. Then you explain your methodology, what you used, the media you analyzed, and the reported findings. So, here, for example, you don't make a conclusion. Like here, he downloaded thousands of images of children being abused. This is probably is not good. You don't really know that as much. What you can say is you analyzed it and found this. You say what you found very carefully. These many images of children and so on. Unless you have some way for it to be a scientific conclusion that you know those children are being abused, you shouldn't say that. You should just say, I have images of children. Now, if they're known pedophile images, there are directories of those, you can go for them, but that's something only the FBI should be touching anyway. That's why, sticking to the technical details is what you have to do, because that's all you're competent to do. Fauci, during the pandemic, was very, very good at this. They would bring him up next to Donald Trump. Donald Trump would say terrible, crazy things like you should use bleach to kill it, and they'd call it Fauci, and Fauci would say, well, all I know is the vaccine has a 95% effectiveness rate, and that means, and you should wear a mask, and that would make you safer. He would carefully stick to the scientific facts that he knew and not get drawn into opinions about anything else. That's what you got to do. You're only an expert in technical stuff, and you don't want to depart from that. All right, then you have exhibits, photos of seized objects, screenshots, and often a glossary, which explains your technical terms. So, the expert witness is a very special person at a trial. Normally, people at a trial can only testify to direct evidence, which is what you saw. Now, if you heard somebody else say something, that they saw something, that is hearsay, and usually not admissible in court. It is the only thing that would be admissible is you can say they said that, but it doesn't mean what they saw was true. However, an expert witness has a special ability to change opinions into evidence. Because an expert witness has expertise, you can say, in my experience, I have stated this opinion after examining the evidence, and that opinion now becomes evidence. However, the strength of that evidence is based on how much the jury trusts you. So you have to impress them. You have to show up wearing a good suit. You have to sound authoritative. You have to have this resume that's 30 pages long, full of you doing relevant things and training and everything to convince them you're really an expert. And you have to be clear and understandable. And they'll judge all of that to decide whether they trust you. And then you can create facts out of your opinion, create evidence out of your opinion. The only person that can do that. An expert witness is the only person allowed to state opinions that matter in court. All right, so that's your goal. Your goal is to break down complex concepts into meaningful information so people can understand what it means. And so you have to prepare a written report, and the report will contain a complete statement of all the opinions you will express and the basis for them, and the facts, data, exhibits, qualifications, list of other cases, and a statement of how much you've been paid. These are all relevant things for the jurors to consider and how much they want to trust you. Let me check for comments. No new ones. All right. All right. So here's some other notes. You can be asked hypothetical questions. For example, one you very often are told is, isn't it possible that this computer got infected by a virus and that put that nasty evidence on there? It wasn't really the accused doing a bad thing. And technically, that is probably always possible. But what you can say is, in my experience, I've never seen that. I do not think that happened here. It is my opinion that that is not what happened here. You can say that. Well, however, of course, nothing is ever certain. One thing that's why teachers are often sought as expert witnesses, because they're very good at breaking complex subjects into understandable explanations. But the defect of teachers is here. You have to only answer the question and then shut up. You can't ramble and keep wandering off and say, oh, this is interesting, and I found this and this. That is not okay, because the lawyer has a plan, and they are trying to guide you with a case. And so you just answer the question you were asked, and then you stop. And if they want to hear more, they'll ask another question. That is hard for teachers to resist, the tendency to ramble. You have to avoid that. Of course, you have to be courteous to everyone. Never talk over someone else, because there's a reporter typing everything that is said. So I can't have two people talking at once. Always be polite. You do have to wear a suit. You have to wear good clothes in court. You can be punished for that. And always be clear. Don't say probably. Don't say I guess. Just say, I know this, I don't know that. I was able to determine this, I was not able to determine that. That kind of thing. Be clear about whatever you detect, be technically correct. And you are allowed to bring your notes and refer to your notes. Let me check here. Was class canceled? Yes, there was no class yesterday. It was some kind of holiday. Anyway, all right. So I'm going to stop this recording.